Let's go on the record on cause number DC 2014261, Baena, Baena versus the City of Mesquite. Councilman, and we can go ahead and proceed. We do not have a record, so but we are doing this on YouTube. You guys may proceed.
Okay, Your Honor. Stephen Henniger appearing for Movement Argyle Independent School District. Oh, I'm sorry, Mesquite Independent School District. This is a plea to the jurisdiction and a traditional motion for summary judgment, Your Honor, seeking dismissal of plaintiff's claims based upon governmental immunity and issues of mootness. The underlying case is a personal injury claim where the plaintiffs were all passengers on a Mesquite ISD school bus that was involved in an accident on October 3rd, 2018. And they're all asserting claims for personal injury damages as a result of that accident. As a local governmental entity, the school district is entitled to the defense of governmental immunity, except and only to the extent that that immunity is expressly waived by statute. And in the absence of such a waiver, the governmental immunity deprives a court of subject matter jurisdiction over a case. In this case, the only waiver that's available to the plaintiffs, and the one that they've expressly brought suit under, is the Texas Tort Claims Act. That statute provides a limited waiver of immunity, not a general one. And while it does,
so the real issue in this case is you guys have paid out $300,000, and that's your cap. That's your argument, right?
Yes.
Okay.
Yes.
Are there? I understand the argument. I guess Mr. Sasson's response is, hey, look, we don't have proof that you've really paid the $300,000. We also don't have proof that this was properly distributed. There was no, I guess, he claims, I'm not saying that this is true, that there was no guardian ad litem's to prove this up. So kind of tell me, and then I didn't see a reply brief. Did you file a reply brief on this?
No, Your Honor.
Okay. So what is that the correct, is a plea to this jurisdiction the correct procedural mechanism or summary judgment to deal with a situation where all of the money has been paid out in the cap? Or I've just never had this issue come up. Is this the right procedure? And then what do you say about the argument about not having a guardian ad litem?
Well, to the first point, Your Honor, I believe it is the proper vehicle in the sense that, the provisions of the Texas Tort Claims Act set the parameters of the waiver. And so one of those provisions is that the district cannot be liable for any more than $300,000 for any single occurrence. Once that's occurred,
I know with insurance cases, and I can't remember the case name, but there's a case that says it's kind of a race to settlement. If you have limited insurance proceeds, it's kind of first come, first serve. I don't know if that's the case when you're dealing with a cap in a governmental entity or not. But do you know what the law is on that issue?
In terms of first come, first served?
You know what I'm talking about? So for example, let's say you have 3 claimants, and there's on a car accident case, and there's a $60,000 policy, and they're all catastrophically injured. There's a case out there, and I can't remember the case, that says the insurance company can pay whoever applies first the full amount if it's appropriate, and then the other folks, and the insurance company's not liable, that there's still other claimants out there. In this situation, is that the same law? Does that same law apply in a situation like this, or does the governmental entity have a duty to make sure that there's a fair distribution, or is there any case law on this?
Well, I don't know if there's any direct case law. The rule you're referring to, I believe, is the one that would be appropriate for a situation like this. But in this case, and I believe Mr. Sasson was a part of this process. There was a express attempt by the district or its risk pool on behalf of the district to negotiate with all of these people. The majority of the money went to the unfortunately deceased girl's family. She got the maximum, the $100,000 max, and then $75,000 went to her sister, who saw the accident, for a bystander claim. So they paid out, almost 60% of it just to those two people, leaving the rest of the 125,000 to be distributed amongst, over 20 claimants as best they could, which they did. And it resulted in the 13 settlements and checks that are attached to the plea. And when that was done, there was just no more money left, and that was the end of the process. And unfortunately, Mr. Sassen's clients weren't included in that amount. But it's just a finite amount of money, and when you have a large number of claimants like this, and it's a little different than like private insurance in the sense that once a carrier exhausts its limits of liability, there may be still potential liability for the insured if they're
Right.
if they got funds. But in this case, there's just no, as a matter of law, there is no further liability, monetary liability, that can be assessed against Mesquite ISD for this accident. And to the point of whether underlying settlements were approved by a court or recommended by a guardian ad litem, I would say first, it's not necessarily true that would be required on every settlement. There are occasions where if there's no conflict of interest between a parent and the child, no guardian ad litem is required. But nonetheless, that issue, whether some minor plaintiff that the district settled with is going to have the ability later to come and challenge the enforceability of that settlement agreement really has no bearing on the issue here, which is it's not disputed. That money's been paid out and it's been accepted and it's not coming back. And that being the case, there's just no further liability for the district. I mean, it's likely a defense if a minor plaintiff tries to challenge this later, saying the release wasn't approved by the court or a guardian ad litem, a defense might be, well, okay, but $300,000 has been paid out. So there are no further claims that can be made. And I wasn't a part of that process. And I don't know, maybe that was some of the underlying thought process when they were settling all these on each end of it for the plaintiffs and the defendant, that they knew the max is going out. And so there's not going to be any chance to litigate this further. Maybe that was why that happened. I don't know, but I really don't think it has any bearing on the preclusive effect of the limits on these cases.
So you cite to a case, Oliveras, it looks like. Do you have a copy of that case?
I don't, Your Honor. I'm looking for Oliveras.
It Olivares. So it says, this is what you quote. You say, MISD has, however, already paid out $300,000 in settlements. Other passengers of the bus who asserted personal injury claims arising from the incident. As such, MISD's immunity has not been waived for any future claims arising from the incident. And you cite to Oliveras, which I assume deals with that particular issue.
Well,
Oliveras again.
Yeah, Oliveras, that's based on the fact Oliveras establishes that the limits for a school district are 100,000, 300,000. That's as opposed to another sort of municipality.
It doesn't talk about what do you do in a particular situation, in terms of if you've paid out the limits and then it's moot. It doesn't deal with that issue or not.
No, it establishes that those are the limits and not the other limits set forth in that section of the statute. That's what the citation is to.
All right, Mr. Sassen.
Well, my position's stated in my brief, Your Honor. I don't know that the validity of those settlements, to the extent that the court took those into consideration, have been proved. In other words, the law sets out specifically, both under the probate code and Texas Rule of Civil Procedure 44, that either a minor who's an incompetent be represented by a guardian appointed by the court, and if not appointed by the court, the guardian may, or the minor incompetent may proceed with the next friend, but it still requires approval of the court. And so in this case, frankly, in hindsight, what I think should have happened was that the monies, to the extent the City of Mesquite School District knew there were multiple plaintiffs, should have deposited those monies in the registry of the court and gotten the court involved with regard to, the settlement. I received, basically, well, I sent out the tort claims notice just out of an abundance of caution within the time period, within 6 months of the accident, to the city of Mesquite. So they knew that my clients, the number of them, of my clients, and that they all had claims. And then there was just complete silence for, a year or so. And I received an email with a pittance of an offer, and then a follow-up email saying, "Oh, I'm sorry, I miscalculated. Your clients are entitled to nothing." We never were engaged ever in these settlement negotiations that took place with the other minor plaintiffs. The other issue too is under contracts law. I don't see how that the city of Mesquite can impose on my clients contracts, the settlements that they were never a party to. And so that said, there's no question the court has jurisdiction. I think that opposing counsel's cite Oliveras specifically states that, and his brief specifically states that our claims fall under the exception to governmental immunity in the Tort Claims Act. So I don't think jurisdiction is an issue. I think what he's, his biggest issue is this issue of mootness. In other words, we've already spent the $300,000, and so we're done. And I don't agree. One, I like the court have searched for any case law that specifically addresses this issue. There is case law out there about insurance claims. Those are contractual between the insured and the insurance carrier. So whatever that document or that contract of insurance states is what's going to control. In this case, and under the Tort Claims Act, there's no guidance, and I haven't found any cases that speak to the specific issues that are raised in this case, and that is, the first come first serve sort of scenario that Your Honors has mentioned and brought up. And so, I think without more, on behalf of the city of Mesquite, I don't think the court can grant their plea to the jurisdiction or their summary judgment.
So has anybody read the Edinburgh Hospital versus Trevino case? 1997 Supreme Court case?
I don't recall that offhand, Your Honor.
I don't either, Your Honor.
It appears to be on. I'm just looking at the Texas CPRC Plus by O'Connor's, and what it says is, when a plaintiff suffers an injury that falls within the TTCA, the legislature has agreed to hold the government liable up to a specified dollar amount. That a plaintiff may have settled with some defendants does not affect the degree of sovereign immunity that the legislature has prescribed. Thus, while the dollar amount of the settlement must be reduced from the verdict under the one satisfaction rule, the settlement does not affect the maximum dollar amount to which the government has agreed to waive its immunity. A settlement with one tortfeasor should therefore be offset before the verdict against the government unit is okay. So that's involving more than one, I guess, a governmental unit and not non-governmental unit, but it talks about offset.
Yeah, I do recall that case. Now that's when the plaintiff is settled with a non-governmental entity and is trying to offset that against their claims against the government, which is not what we're dealing with here, where we're dealing with settlement payments by the governmental entity that reach the maximum.
Okay.
in the wall that I've run to in the discovery process in this case, Your Honor, and I'm not chastising or complaining about Mr. Henniger, but is that, when I try to dig into the settlements that were made, the decisions and processes that were utilized in determining what amounts were paid to whom, I run into privilege objections that I can't get around. So I'm just dealing with, barefaced documents and kind of a promise of, yeah, we paid this.
Well, Your Honor, I think it's more than that. I mean, you've got a set of negotiated checks amounting to $300,000, settlement agreements amounting to $300,000, and testimony from the director of the risk management department that oversaw this stuff that those amounts were paid. So it's not just a bare assertion without evidence.
So tell me again. So 100,000 went to the deceased child, and another 75 to
the deceased child's sister.
Her sister. She witnessed the fire on the bus that killed her sister. So she had a wrong claim.
Has anybody looked at Herman Hospital versus Martinez? 990 Southwest 2nd, 476. Mr. Bassett, I would write that down if I were, both of you should write it down.
Yes, sir.
What was the site, Your Honor?
Herman Hospital versus Martinez, 990 Southwest 2nd, 476. So isn't it 100, 300 limit?
100 per person, maximum to a maximum of 300,000 per occurrence.
That's true. That's just by statute, Your Honor. It's 100,000 per person, 300 aggregate.
Okay, so I guess this one's just okay. Maybe it isn't. It says an exception applies where a person qualifies for recovery as a bystander, as when he witnesses the death or injury or death of a loved one, and thus suffers his own personal injury in the form of shock and mental anguish. In that case, his injury is not derivative but direct. He may qualify as an injured person. Okay, so that allows you. I was wondering if the 75,000 should have been paid, but it sounds like the final determination out of that case is consequently mothers and daughters bystander claims of monetary awards were direct, not derivative, nor subject to injured son's monetary cap on recovery. So I guess that would allow them to pay the 75 out, but you might want to look at that issue. I mean, from what it appears to me is, I understand kind of why the Mesquite ISD brought this, which is, hey, look, we paid our 300, you're not getting any more money. What it appears happens in these situations, though I'm just kind of reading these annotations quickly, is that let's say they only paid $295 and you went to trial and you got $10 million, you'd only be able to recover the $5,000 that hasn't been paid. But I don't see anything here that says just because you paid the 300, it's therefore moot and you can't go forward. I just wonder what the point is if they've really paid the 300 because you can't recover anything if that's the case. And so
that's what makes it moot as a matter of law. I mean, if a court judgment won't change the relationship of the parties, the case is moot. I mean, if we go to trial in this case and they get a $100,000 verdict, the court can award them no money because $300,000 already been paid.
Is there a difference between mootness and pointless? I guess that's my question is, yeah. I don't see anything in the case laws that support your argument. Maybe there is something under mootness, but I'd say to you, Mr. Sasson, if they paid the full amount, you're not getting any money. And so what's the point in us going forward?
Right. And I understand what you're saying, Your Honor, and mootness is not applicable. I mean, and I think you're 100% right. There's a big difference between mootness and pointlessness. And yeah, I'm looking at more the pointlessness argument and trying to get around that as opposed to mootness, because mootness, there is a genuine dispute that's recognized under law and the facts of this case between the parties. So I don't think mootness is even applicable. But like you said, I've got to determine whether or not there's a way, some way around the pointlessness. That being, they've already
Is there,
paid up. Go ahead. I'm sorry.
yeah, so I guess the only thing I would say is that I think this probably is pointless. I'm assuming that, you know, they really have paid the 300,000, that there's, I mean, I think they gave you, you know, canceled checks, but so the only way around that would be if you could find a case or statutory provision that says that they have a duty to, you know, exercise good faith and distribution of these funds or something, which I kind of doubt is going to be the law, but
Right.
you know, maybe there's something there. You know, at this point, I'm going to take it under advisement, and if you guys want to give me additional briefing, you can. I would strongly consider Mr. Sasson just.
I hate the non-suit. I
Yeah.
mean, it just sort of out of an abundance of caution and reporting back to my clients. I'm happy to send
Let me do this. Let me